Hi, thank you so much for joining us. We will get started in a few minutes. We're giving people time to join. I see more folks coming in. We're going to get started in a few minutes. We'll give it about one more minute or so, and then we'll get started. All right, we will go ahead and get started. Hi, everybody. Welcome to tonight's webinar on the decision-making tools for education. We are excited to have you here tonight. My name is Casey Anderson, and I am the Communications Manager for the Council for Court Excellence. CCE is a nonpartisan, nonprofit civic organization. For nearly 40 years, CCE has been a catalyst for change in the district, working on civil, criminal, and youth justice reforms, while also educating and empowering DC residents to know and exercise their rights. CCE identifies and proposes solutions by collaborating with diverse stakeholders to conduct research, advance policy, educate the public, and increase civic engagement. We've published and distributed over 300,000 copies of plain language booklets, guides, and other materials explaining various areas of the law and court processes in the District of Columbia. You can find electronic copies of these guides on our website, which is www.courtexcellence.org. We CCE, with significant help and contributions from Quality Trust, AARP's Legal Counsel for the Elderly, and Disability Rights DC, a university legal services, published When Adults Need Help Making Decisions and Managing Daily Affairs, a non-lawyer's guide to DC's legal tools for assisting adults. It's a comprehensive guide for DC residents on legal tools available for them to assist adults who, because of illness, injury, physical or intellectual disability, or simply the effects of aging, may need additional assistance making decisions. This webinar is an outgrowth of CCE and Quality Trust collaboration on this guide. And although CCE's guide covers a full range of adult support in DC, this focus today is on educational supports.
Good evening. My name is Holly Caesar. I'm the Jenny Hass Justice Project staff attorney at Quality Trust. Quality Trust is an independent nonprofit advocacy organization dedicated to effective advocacy and legal representation for people with disabilities. For nearly 20 years, Quality Trust has worked to improve the lives of children and adults with disabilities and their families in the District of Columbia. Quality Trust works with individuals and family members to solve problems, identify opportunities for learning and contribution, and find creative ways to minimize differences and make the most of each person's abilities. And Quality Trust Jenny Hass Justice Project is dedicated to advancing the decision-making rights of people with disabilities and helping them avoid undue or overbroad guardianship. We provide legal assistance to DC residents who have questions about their decision-making rights, who are in a guardianship that they are unhappy with, or who want to explore less restrictive forms of decision-making support, such as supported decision-making, powers of attorney, advanced directives, and other legal options. Next slide, please.
And I just wanted to introduce myself. I work with Holly. My name is Morgan Whitlatch. I'm the legal director at Quality Trust for Individuals with Disabilities, and I'm happy to be here today. Go ahead,
Thanks,
Kelsey.
Holly. So my name is Kelsey Woodford. I am a staff attorney at Disability Rights DC. I focus largely on our grant to help people with mental illness living in the district, and also on our grant for people with developmental disabilities. About half my clients are young people, so this issue is very near and dear to my heart. I work as both a behavioral health attorney and also a special education attorney. So Disability Rights DC is the federally designated protection and advocacy agency for Washington, DC. And what this means is that we have the power, but also the responsibility under federal law to protect and advocate for the rights of people with disabilities. The way that we do this is we engage in a variety of activities. These include individual representation, systemic advocacy, community outreach, and education, and also investigation of abuse and neglect. All of these services are provided free of charge and eligible individuals with disabilities according to our annual priorities and objectives. Next slide.
So in case you have forgotten, these are our lovely panelists, and we are really excited to have them here tonight talking about these tools.
So today we're going to be discussing decision-making tools in regard to education. The list above proceeds from the least to the most restrictive legal tools. And during this webinar, we will place an emphasis on the newest, most flexible, and least restrictive tool, supported decision-making. In the right circumstances, it can be highly effective and used without having to hire a lawyer or involve the courts. It also avoids the restrictions on personal autonomy and the rigidity of the more traditional tools of guardianship and conservatorship. It's therefore consistent with an overarching principle of DC law that supportive arrangements allow the greatest degree of self-determination possible, consistent with the mental and physical limitations of the person needing help. Next slide, please.
So we want to talk about what happens at 18 years old in DC. The age of majority in DC is 18. And what that means is that when a student turns 18, they are considered an adult and presumed by the law to be able to make their own decisions, even if they have a disability, even if they're in special education. Their educational rights, which had been exercised by their parents when they were a minor before they turned 18, now transfers to the adult student. In the special education context, we refer to this as the transfer of rights. In the past, when a student who needed some support turned 18 and was thus considered as a legal matter to be an independent adult, the traditional advice had been for the student's parents to seek guardianship, even though all of the restrictions and protections of guardianship weren't actually necessary. Now, however, there are less restrictive, less formal, and less expensive alternatives that should be pursued rather than guardianship. Next slide, please.
So what is supported decision-making? At its most basic level, supported decision-making refers to a common everyday practice with which we are all familiar. That is, asking for the advice or thoughts of another person or persons before making an important decision. It's given a special name in the context of people with disabilities, including students, to remind us just because they may need more or different kinds of help in understanding the decision to be made does not mean that they cannot make the decision. In this way, supported decision-making can be seen as a reasonable accommodation for a person's disability. Supported decision-making refers to a broad range of arrangements that enable people to obtain guidance and support without giving up their legal right to self-determination. They can choose one or more trusted family members, friends, or advisors to provide help in understanding, making, and communicating significant life decisions while retaining the right to make those decisions for themselves. And studies have shown that people with disabilities who have more self-determination, more direct control over their lives, usually have better jobs and a higher quality of life, are healthier, are better problem solvers, and are better able to fend for themselves and to avoid abuse. Supportive decision-making has been acknowledged by the American Bar Association, Department of Education, and Department of Health and Human Services, among others, as a helpful tool for individuals who need extra help to make or communicate their decisions. And for over 7 years, supported decision-making has been recognized in DC as an option for adult students in special education who can remain in school until they turn 22 or graduate with a high school diploma. And DC Public Schools incorporated supported decision-making into its transfer of rights policy beginning in August 2013 and created a forum by which to document supported decision-making arrangements between adult students and their supporters, which we will be talking more about shortly. Also, keep in mind that in August 2013, DC lawmakers passed a law confirming supported decision-making as an option for adult students in special education. In July 2016, the DC Office of State Superintendent of Education adopted rules recognizing supported decision-making and issued a model supported decision-making form. And in May 2018, DC became the 4th jurisdiction in the US to enact legislation expressly recognizing the legality of supported decision-making agreements. And these agreements can now be used across the lifespan and in all life areas, even those beyond education. However, we will be focusing today on supported decision-making and its role in education. CCE's When Adults Need Help Guide contains information on how to get an electronic copy of the Statutory Supported Decision-Making Agreement form. Next slide, please.
So we want to talk about what the steps are to establishing a supported decision-making agreement. We're going to talk about the specific supported decision-making forms in a minute, but first let's talk about the basics of the arrangement itself, regardless of whether or not it's actually formalized on paper. So there's no one-size-fits-all method for supported decision-making. This form of decision-making, regardless of whether or not it's in the educational context, is going to look different for different people. People have different needs and different support networks. People have different ways of communicating. And the key question is, what will it take to successfully support the person, or in this case, the student? It's critical that supporters work with the person and identify where the help is needed in order to support that person in making their own decisions. Supporters do not make decisions for the person with the disability. Instead, what they do is they help or they communicate their own decisions, such as where they want to go to school, what kinds of services and support they want, what they want their vocational or educational transition services to be. And supporters can also explain these choices that the person faces in a more easily understood and understandable way. They can ask questions for the person, they can help gather information, or they can assist with the person's communication to others. The supporter should be an adult that the person chooses and trusts, someone who knows, who wants to become their supporter and who wants to act in this role, who wants the person to make their own decisions and who is trustworthy and reliable. And finally, it should be someone who's not likely to hurt or exploit the person in some way. Next slide, please.
So what is a supported decision-making agreement? It's a way of formalizing a supported decision-making arrangement by putting it into writing. In DC, there are 2 options for how students can create a supported decision-making agreement in the educational context. First, an adult student can use a supported decision-making form from either the DC Public Schools or the Office of the State Superintendent of Education. Or an adult student can use a supported decision-making agreement form that's statutory in nature that complies with the broader supported decision-making legislation that was enacted by DC in May 2018. And we're going to talk about each of these options in a moment. Next slide, please.
So who cannot be a formal supporter under an educational statutory decision-making agreement? One important thing to keep in mind when using a supported decision-making agreement to formally record a supported decision-making arrangement is that there are special rules for who can be a formal supporter. Under the law, there are certain people who cannot be a formal supporter under an educational supported decision-making agreement. Unless the formal supporter is a relative of the student, the formal supporter cannot provide or own or operate a provider of healthcare or disability services to the supported person. Unless the formal supporter is a relative of the student, the formal supporter also cannot work at any governmental agencies that are financially responsible for the supported person's care. So depending on the DC student, that could include, for example, employees of the Child and Family Services Agency, CFSA, or DC Healthcare Finance, the DC's Medicaid agency, or the Department on Disability Services, DDS. So we are focused today on the support decision-making agreements in the context of educational decisions. For support decision-making agreements that are for decisions other than those related to education, there are additional rules relating to background and criminal history that can disqualify someone from being a formal supporter. However, those additional rules do not apply to supported decision-making agreements that are only for educational decisions. Next slide, please. If the supported decision-making agreement covers educational decisions and other kinds of decisions like financial or healthcare decisions, there are additional rules. Even if they are your relative, a formal supporter cannot been found by a governmental agency to have abused, neglected, or exploited a supported person or inflicted harm upon a child, older adult, or person with a disability. 2, they cannot have within the last 7 years been convicted of certain crimes, including sexual offenses of aggravated assault against a child, older adult, or person with a disability, fraud, theft of $1,000 or more, forgery, or extortion. And 3, unless a supported decision-making agreement is for educational decisions only. That is the only exception there. Next slide, please.
So how do we actually make an educational supported decision-making agreement? There are 2 options. The first option is that you use a form from DC Public Schools or the Office of the State Superintendent for Education supported decision-making form. This form needs to be signed and dated by the adult student and also by their formal supporters, but it does not need to be notarized. The second option is that you can use a statutory supported decision-making agreement form. On the line where it allows the supported decision-making to list the supported person to list any other duties of the formal supporter, that person can write in the authority to support educational decisions. This form needs to be signed and dated by the adult student and their formal supporter in front of a notary and 2 witnesses. The person with the disability also will need to sign a Family Education Rights and Privacy Act, or FERPA, release of information form, and attach that to the SDMA form. Next slide, please. So for both of these options, the person with the disability should give a copy to their school or their educational provider. The person with disability does not need a lawyer to complete these forms or have a court approve the form. The supported person or their supporter can cancel or change the supported decision-making agreement at any time. And it should be done in writing, and copies should be given to the school, the person with the disability, and their supporter. Next slide, please.
So let's turn to a concrete example of using a supported decision-making agreement. Jose just turned 18. He has an intellectual disability and he's going to be receiving special education services through his school until he turns 22 years old. Although his parents want Jose to gain experience making decisions on his own, they also want to continue receiving information about his educational progress from the school. They're concerned that the school will stop sharing information with them because Jose is now 18 and a legal adult. They need that information in order to help Jose understand how he is doing in school and whether he needs additional educational services. Jose thinks his parents can help him make his own decisions, and he wants them to. So he and his supporters sign and date the 1-page DC Public Schools supported decision-making form because he goes to a DC public school. Because they are using this DCPS form and not a statutory supported decision-making agreement form, they do not have to have 2 witnesses or a notary signed. And they also do not have to use one separate form for each supporter. So there can be really a lot of advantages in using the DCPS and OSSI forms for people who just want to use supported decision-making within the special education context. They're shorter, they're easier to complete, I like them in that way. If you want a supported decision-making agreement to cover more than just educational decisions, that's when you're having to turn to the statutory supported decision-making agreement form. Next slide, please.
We are now going to transition to a discussion on an education power of attorney. An educational power of attorney is a legal document that allows the adult student called a principal to appoint a representative called an agent or attorney in fact to act on the adult student's behalf in educational matters. It's different from a supported decision-making agreement because the agent, unlike the supporter, can make educational decisions for the adult student. Despite the terminology, the attorney in fact does not need to be an attorney or a lawyer. The person creating the power of attorney can appoint a family member, a close friend, a trusted advisor, or another trusted adult to serve as his or her representative with educational decision-making authority. And when you establish an educational power of attorney, you are giving someone else the authority to make important and sensitive educational decisions on your behalf without any review or supervision by the courts. And giving someone that power can have serious consequences. Therefore, it is absolutely critical that the person to whom you give such power be completely trustworthy and reliable, have sound judgment, have the time, availability, capability, and desire to fulfill the responsibilities described in the educational power of attorney, and understand your wishes and be willing to follow them. Before making someone your educational agent, you should discuss your preferences and wishes with a potential agent to ensure that he or she fully understands and is willing to comply with them. And an educational power of attorney can provide that the agent's powers start immediately, at a specified later date, or when a particular future event occurs. You should also make sure that the document accurately and clearly expresses your wishes, that it addresses all potential contingencies and consequences, and that it complies with the DC law. Next slide, please. The person granting the power must sign a power of attorney while they have the mental capacity to do so. This person can cancel or change it at any time. If any changes are made to the power of attorney, it should be in writing and copies given to anybody who has a copy of the original. Also, it's important to note, DC law requires power of attorney contain specific elements, such as notarization, in order for the document to be legal. It's very important that the power of attorney be completed correctly in order for it to be considered legally sufficient and enforceable. You should also consider having a lawyer draft and review the educational power of attorney. Next slide, please.
So I get this question a lot. How is the power of attorney different from guardianship? A power of attorney is different from guardianship for a number of reasons. First, the person seeking support is the person who decides what power to give their agent and who their agent is. That's not a decision that's made by a judge in court. The second big difference is the person seeking support can cancel or change the power of attorney without going back to court and getting special permission. And third, a power of attorney does not involve a court adjudicating that a person is incapacitated. Okay, so powers of attorney really are voluntary tools that a person who wants certain kinds of support or wants an agent to act for them can knowingly and voluntarily execute to have control over the decisions that their agent has control over and can act for, but also they can change their minds. And that's the really big difference between powers of attorney and guardianship. And I say, powers of attorney are really flexible tools and really great tools to be using for transition age youth whose ability to make decisions are going to grow over time, but who may need more support when they reach the immediacy of adulthood. Next slide, please.
So let's talk about an example of an educational power of attorney. This is Marie. Marie has an intellectual disability and she just turned 18. She is going to be enrolled in special education until she is 22 years old. She's been having problems getting the special education services that she needs while in school. It looks like it will be necessary for her to file a due process complaint and go through a formal hearing process to challenge the school. Marie is concerned that she will not be able to navigate the complicated and challenging legal process herself, but she trusts her mother to do it for her. In front of a notary, Marie knowingly and voluntarily signs an educational power of attorney that gives her mother the power to be her educational agent for the purposes of making a legal claim against the school. Next slide, please.
An educational representative is someone, usually a parent, appointed by the DC Office of State Superintendent of Education, also known as OSSE, to make educational decisions for an adult student with a disability who is receiving public special education and who, one, cannot make his or her own educational decisions even with the support of others, or two, lacks the capacity to sign a power of attorney appointing another person to make educational decisions on his or her behalf. To be appointed as an educational representative, a parent, another adult relative, or another interested adult must submit a written request to OSSE using its required form, a link to which can be found in the CCE guide. The student must be at least 18 years old or must be turning 18 within the next 90 days. The person filing the application for appointment also must submit certifications from 2 professionals that comply with the requirements of OSSE's model certification form. Those requirements include: 1 certification must be from a licensed medical doctor, a qualified physician assistant, or a certified nurse practitioner. The other certification must be from a licensed medical doctor, a psychiatrist, clinical psychologist, or independent clinical social worker. The professionals cannot be employees of the student's public school or public charter school, and each of the professionals must have personally examined or interviewed the student within 1 calendar year of the certification and found that the student to be unable to give informed consent for educational decisions. The professionals cannot base that finding solely on the student having been hospitalized for mental illness or diagnosed with intellectual disability. And the professionals must also inform the student in writing of their findings. A link to the OSSE model certification form can be found in CCE's When Adults Need Help guide. Next slide, please. There are a few additional items to note for an educational representative. A lawyer does not need to complete any of the forms. A student may challenge the appointment of an educational representative at any time. If a student wishes to make such a challenge, he or she should contact OSSE, preferably in writing. OSSE will help with documenting the challenge. Also important to note, an educational representative's authority automatically ends when the student is no longer eligible for special education services or graduates with a high school diploma or certificate, whichever happens first. And lastly, the filing of a student challenge automatically cancels the existing certifications and educational representative appointment and causes all educational rights to transfer back to the students. Next slide, please.
So for an educational representative example, this is Michael. Michael just turned 18 and he will be receiving special education services until he turns 22. Although he attends his individualized education program meetings this year, his father, Kevin, and the special education multidisciplinary team believe that Michael is unable to understand fully, even with help, the educational decisions that he is expected to make. Kevin considers becoming Michael's agent through the educational power of attorney, but it does not seem like Michael understands the power of attorney form, which is one of the rules. Instead, Kevin needs to use the process for becoming an educational representative. Kevin gets written certifications from Michael's doctor and a psychologist that Michael lacks the mental capacity at this time to make his own educational decisions. Kevin submits these certifications and a request form to OSSE and is appointed Michael's educational representative. As a result, Kevin can continue to make Michael's educational decisions for him until he turns 22. Next slide, please.
We are now going to briefly discuss guardianship, which is the heaviest tool in the toolbox of decision-making supports and the one that should only be used as a last resort. Because this webinar is focused on educational decisions, I want to highlight that guardianship is not necessary to make special education decisions for adult students who cannot make them for themselves. Why? Because as Holly discussed and Kelsey gave a concrete example of, DC recognizes and has a process for appointing educational representatives without the restrictions associated with court involvement. So turning back to guardianship, only a court can establish a guardianship. So when a parent calls me and says that they're the guardian over their adult child, I always ask, have you been to court? And if they say no, then I know that they're not, in fact, the legal guardian, because it does involve a court proceeding. Guardianship is a formal legal process where the court makes two determinations. First, the court determines whether an adult is incapacitated, meaning the person's ability to receive and evaluate information effectively or to communicate decisions clearly is so impaired that the person cannot manage their health, safety, finances, or other needs without the appointment of a guardian. Second, the court determines whether it's necessary to appoint someone else, namely a guardian, to make all or some of the decisions for a person. What does necessary mean? It means that there's no effective, less restrictive options that are available. In other words, all of these other less restrictive options that we've discussed today have been considered and won't work for some reason. A guardian is responsible for helping, protecting, and making decisions for a person who lacks or has lost the mental capacity to make important life decisions or to manage his or her own affairs. Although it is needed in some cases, it should be the tool of last resort because it's a serious restriction on a person's civil rights. Again, if the kind of decision-making support has to do with special education-related decisions, guardianship should not be necessary for adult students who cannot make their own educational decisions in a special education context because DC recognizes educational representatives. Next slide, please.
When necessary, the court may appoint a family member, professional, or others as a guardian. Guardianship can be temporary, limited, or general. And guardianships can be time limited and can also be limited to specific life areas. For example, it is possible for a person to have a guardian for only healthcare or to have a conservator for significant assets. A permanent general guardianship is the broadest type because they are not time limited and cover all kinds of choices, including the management of a person's daily decisions like healthcare, housing, education, public benefits, and income. And guardians also have ongoing responsibilities to the court and are required to file reports every 6 months. It's also important to note that guardianships established after January 1st, 2015 are reviewed by the court at least every 3 years. This guardianship assistance program does an investigation and writes a report stating whether they think guardianship is the least restrictive option, and the judge then decides whether the guardianship should be maintained, modified, or terminated. Guardian's decisions should be based on substituted judgment, which means what the person would decide if they could. Only if the person's wishes are unknown and cannot be ascertained should a guardian switch to a best interest standard. Next slide, please.
So it's important to think about what the limitations of guardianship are. The first is that it can be expensive and time consuming. Also, you have to involve judges, lawyers, and other court officials. Changing or editing it can be extremely difficult and requires additional court proceedings and expenses. And finally, guardianship can limit a person's freedom and their ability to exercise self-determination. And we know that self-determination is linked to better life outcomes. Therefore, establishing a guardianship is a serious step, and it should be taken only after careful consideration, including an assessment of whether there are less restrictive alternatives that could provide adequate support and protection for the person. Next slide, please.
Thank you so much, everyone. So this concludes the presentation portion of the webinar. If folks have questions, please feel free to put them in the chat or use the Q&A function. I know Kelsey, Morgan, and Holly are all happy to answer any and all questions that you guys have. There's also a short survey at the end of this webinar when I close it out. If you wouldn't mind taking a minute to fill out that survey, that would be greatly appreciated. But now we welcome any questions you have.
I actually had a question messaged to me privately, and I think it's a wonderful question. So I'd like to read it to all of you. The question I received was, Do you need to be able to read and write in order to sign a power of attorney for education? I think this is a wonderful question. I appreciate you asking that. So no, you do not need to be able to read or write in order to sign a power of attorney for education. We've had clients that are able to voluntarily and knowingly sign a power of attorney for education, even if they cannot read, for example. The individual will need to sign by mark, which is something like signing with an X, and do it in front of a notary. So that's something that has been done before and is a good alternative to it. So thank you so much for asking that question. That was a great question.
Well, I have a question for some of the panelists that I'll ask. I have heard a lot of, myths about guardianship and alternatives in the work that I do when I'm working with families who have questions about the decision-making rights of adult students. And I can think of a couple of really big myths that I've had to kind of bust in having those kinds of conversations with them. What about you, Kelsey and Holly? What is one of the biggest myths you've heard that people have to, when you're counseling a family member about alternatives to guardianship? Kelsey, do you have a particular myth within the mental health context?
I think something I hear a lot is people thinking that because someone is 18, that they are fully done developing and done sort of changing. And, I think that this is something that comes in with the educational representative example. But also with, a power of attorney is, I have several clients who turn 18, they're still in school, they're figuring things out, and they're young people, and oftentimes they have a behavioral health diagnosis. And particularly with my young men, there's so much that happens between the ages of 18 and 22 when they may exit school, or even just in a 6-month period, they can change so much and mature so much. And that's one thing that I really love to counsel families about in particular is, just because you saw someone at 17 and a half and you think what they're going to be like forever, we all need some time, and we're not done fully developing when we're 18 years old. And so giving people a little bit more space and not jumping right to something like a guardianship, which it really is a nuclear option and takes away a lot of rights, I think is critical.
I think that's a really great example. What about you, Holly?
That is a great example, Kelsey. And I could not agree more with what you said. Kind of going off of that a bit, to me, one of the things I am most passionate about is the conception of capacity. This question of capacity is not something that is set in stone, and I find it so incredibly fascinating to talk about it with families. Capacity can grow over time, and it is something to digest and really understand. That is not something that the minute you meet someone may be subject to that in the moment. Over time, their capacity could grow with practice. And it's something that you have to keep in mind, that jumping to guardianship before considering alternatives to guardianship is not an ideal route, because a lot of times people can get support, grow more, and have a better understanding of what it means to make decisions, have support, and with time, may be able to develop more skills of independence with practice and with people that care about them and help them grow into that role. So it's very important to know that capacity can change over time, can evolve, and with practice, it is very possible.
That's a really great example as well. Capacity being part of a continuum that changes over time, I think is a really important thing to kind of keep in mind. One of the big myths I hear is people tell me, well, Morgan, I'll go get guardianship over my 18-year-old son. And then if I change my mind, I'll just cancel it. And that's a big myth, because when you get guardianship, what it means is that the court is adjudicating somebody is the son in this case is unable to make decisions themselves. And it's really the court that's taking that decision-making power in itself, and it's delegating it to a guardian. So it's the court's decision about whether or not to modify or terminate the guardianship. And I'm going to tell you, it can be really hard to get out from under a guardianship. I've worked, for example, with families who got guardianship when their child turned 18, because that's what everybody was telling them to do. And now their child is 30, and they say, look at all the great things he can do. He doesn't need to have a guardian. I need to cancel it. And yet you have to show a court something's changed. And it can be hard to show a diagnosis has changed, right? You need to be able to get expert support. You probably will need to get representation. It can be very challenging to undo or terminate a guardianship. And so we really encourage people who are, who are supporting transition age youth to recognize that big step it is for guardianship. Sometimes it is necessary, but frequently there are lots of alternatives that can be used that can allow the kind of flexibility a young adult needs to be able to grow and become the adult. None of us made great decisions when we turned 18, I'm sure. And we should give people with disabilities that opportunity to grow too. So that's what I would say will be one of the biggest myths that I hear. Any others?
Well, I did just want to jump on, Morgan, your point. Morgan and Holly have actually been sort of invaluable in teaching me in my first year of practice in this role about sort of what guardianship can look like. And one thing that I think I see with a lot of clients that are particularly transition age is that they have a parent, a mom or a dad, or maybe an older sibling who really has a great rapport with the person with the disability, and they really can communicate with them extremely well. And so they sort of say to me like, well, if I'm his guardian, I know that I will be able to sort of make decisions in his stead, make his expressed interests. I can communicate with him. But I think what they don't realize about guardianship is, like Morgan said, it's so hard to get out from under, is if that person, if that parent, or if that sibling can't do it anymore for whatever reason, there's still a guardianship in place and the court can assign somebody else to that guardianship. So, that's one reason to really think carefully about it, is that you may have a really special and close and powerful relationship with your family member, with the person you're supporting. But that guardianship is bigger than just your relationship. And I think that's just an important thing to keep in mind.
Absolutely. There really are myths about guardianship that are out there. I also see that there are some myths about supported decision-making that is out there. I don't know how you guys sometimes hear about this. Like I'll hear sometimes like, oh, well, supported decision-making doesn't apply in this case because of the person has a certain kind of diagnosis or something like that. Like, oh, they have, a schizophrenia diagnosis, or they have an intellectual disability diagnosis. And, the reality of the situation is supported decision-making isn't ruled out by anyone's diagnosis. It's a much more fact-specific kind of, approach that you should be taking when you're doing this with supported decision-making. I've worked with many, many, many people with intellectual and developmental disabilities and mental health diagnoses that can use supported decision-making, that can knowingly and voluntarily sign a power of attorney or advance directive. And I've worked with some that can't. But I've worked with many, many more that can. And so I really try to encourage us when we think about capacity as being a continuum. So too, don't rule out the possibility of these less restrictive options simply because of a certain kind of diagnosis. What about you guys? Have you heard any kind of myths about supported decision-making?
So Morgan, everything you said, I agree with very, very much so. And I will say that it's also important to note that certain communication styles that individuals may have. So it may be important that you communicate in different ways. Some people, like myself, are very visual learners. Some people will find that maybe just having a general meeting where you're talking to them is not going to be effective. So it's important to consider that someone may have the capacity to sign a support decision-making agreement if you're having a meeting that's focused on a visual meeting. So for me, for example, I really enjoy making PowerPoints for potential clients. And we go through the concepts through a PowerPoint, focus on their interests and focus on the concepts through photos of them, their family, of their interests, things that they enjoy, to really get connected with them and make sure that we are communicating in a way that they understand. And I think that's a really crucial thing to keep in mind, is just having a meeting, talking to someone. The person may not be digesting the material, but if you remain open-minded and see that a different type of meeting that is visual, for example, may be a very effective way of having a meeting and someone actually having capacity. So don't rule out someone's capacity to sign something until you try different forms of communication.
Great, Kelsey, do you have anything to add?
Go ahead.
No, go ahead, Kelsey.
I just appreciate that point so much, especially working with transition age youth, because, a young person walking into a room, sometimes it's just, you need, just like any teacher knows, you need to create an environment in which they're comfortable. And I think that's critical. Morgan, whatever you were.
No, I think I was just saying, Kelsey, if you had any statement, I think that was a great statement. I think we have to, we don't judge people's capacity on a moment's meeting, and I think that's an important piece of this. So we did get a question. Is substituted judgment a statutory standard for guardians? And is this standard applicable to guardians in other jurisdictions? So I'll take a first stab at this and then others can pipe in. So substituted judgment is a statutory standard in DC's guardianship law for guardians. Is that standard applicable to guardians in other jurisdictions? It depends upon that other jurisdiction's state law. So that's, that's an important kind of distinction. There is best practices done by the National Guardianship Association that says that, substituted judgment is best practice before using a best interest standard, and that you actually should be using supported decision-making before pursuing guardianship, but also the principles of supported decision-making within the guardianship arrangement, so guardians can support people in building capacity. But I can't say that's the statutory standard in every state. It is the statutory standard in DC. Does anybody have anything to add, Holly or Kelsey?
I think that this is an interesting point more broadly, especially sort of within advocacy, that you have to go with people's expressed interests. And so I think for me, I feel like coming into sort of advocacy as a young lawyer, that takes a little getting used to, but it's so critically important for giving people dignity and empowering their voices rather than speaking for them. And so I think that's a powerful thing that I'm glad to see that DC recognizes within our jurisdiction.
And I'm posting now the NGA statement so that you can see what I was talking about. So I wasn't just, you can look at that National Guardianship Association statement on supported decision-making and principles of supported decision-making within guardianship. Great question. Any other questions?
Or comments? We love comments.
We love comments, yeah.
As we wait to see if anyone else has a question or a comment, Morgan, Holly, Kelsey, if you guys feel comfortable or don't mind putting your emails in the chat, if folks have more specific questions. Folks are also welcome to email me, and if it's a question I cannot answer, I will direct you to one of these three lovely ladies who are able to answer it. Thank you so much. So we'll give it one more minute or so, just in case we have any last questions, or if folks want to jot down the email addresses before I close this out. Thank you so much, everybody who attended and listened. We really appreciate it, and we hope that you found this helpful. Again, there is a survey at the end of the webinar, so if you don't mind filling that out, that would be greatly appreciated. Have a good night, everyone.
If it's okay, Casey, can I allow both Kelsey and the Quality Trust team to give a little plug for our services?
Absolutely.
If you don't mind. Okay, so as Holly described, Quality Trust runs the Jenny Hatch Justice Project that helps eligible DC residents who are interested in exploring the very alternatives that we are discussed here today. I'm going to put into the chat box information that you can read more about some of the cutting edge work we're doing. Kelsey, want to talk about Disability Rights DC?
Always. Yes. So Disability Rights DC, as I mentioned earlier, we are the protection advocacy agency for DC, and that means that we are able and are tasked with working with people with disabilities, a wide range of disabilities in the city. So I, as I said, work with clients who have behavioral health diagnoses and also developmental disabilities. I have colleagues who work more with physical disabilities. I have a colleague who yesterday, I think, went to the 14th and U metro stop and was, making sure that it was architecturally compliant with ADA. So we work with all different kinds of things. And if you call us, you can describe whatever's going on, and we will either help you ourselves, or if we either don't have the resources, or it's outside of our priorities, or it's just something that we don't typically do, we will know where to direct you. So I always encourage people to call, and our intake specialist is awesome, and she will work with you and we'll help you figure it out.
Thank you so much. All right. So with that, I will say good night, everybody. Thank you so much for your time. Thank you to our wonderful speakers. I hope everyone has a great evening. Bye.